Good morning, and I want to thank everyone involved with inviting me, Bob Hauser, I think, and other folks here, and Siobhan for welcoming me. I'm delighted to be back here again today. The United States Supreme Court is asked to decide about 8,000 to 9,000 cases every year. It only writes full opinions in about 60 to 100 cases, barely 1%. Obviously, the Supreme Court tries to take cases, purposefully tries to take cases that it thinks has a national impact and a need for national uniformity in the decision of the law. But most of us pay not that much attention to the Supreme Court cases because sometimes they're about some minute statute of criminal law or bankruptcy law that'll put you to sleep, or tax law that will also put you to sleep, unless you are the plaintiff or perhaps defendant in a criminal case. The Supreme Court also decides about 2 or 3 Indian law cases every single year, and those of us that practice Indian law pay great attention to that. It's important to the plaintiffs, the tribe in that case. But Indian people only make up about 1.5% of the population of the United States, so one might think that these cases have kind of a minor impact across the country, even if they do impact many of the 574 federally recognized tribes that there are across the United States. But on July the 9th, 2020, my wife woke me up in the morning and she goes, "I think the tribe won that case." And I couldn't believe it because I saw the impact of the case I'm going to talk to you about. What case am I talking to you about? McGirt versus Oklahoma. My wife says that since July the 9th, 2020, in our house, it's been all McGirt all the time. I wrote an article, my first article on the subject, I called the case a bombshell. And some people told me, and in fact I said it was the most substantial, significant Indian law case in 100 years. And I had a few people tell me, "Bob, you're kind of hyping that, it's not." But folks, 4 years later, the case has barely begun to roll out and impact the state of Oklahoma, and it has led to a decision I'll mention to you in a moment that changed Indian law in the entire country. So I think the one thing I ever accurately prophesied in my entire life was that this case is a bombshell. So what's a bombshell case? I mean, just even if you're not in the law, Roe versus Wade and the right to abortion in 1973, look what that led to, the political activity, the protests. I do believe even a few abortion providers were murdered. And now the court reverses Roe versus Wade in 22. Brown versus Board of Education, 1954. We're still working on those issues, aren't we? So a case like that is so significant. So I am afraid that McGirt is going to be, well, I guess I shouldn't say afraid, but I'll talk to you in a moment what Justice Neil Gorsuch hoped when he wrote the opinion, and where we're at today, and why I call this case a bombshell. The case implicates both the treaty clause of the Constitution and the supremacy clause. They are both in Article 6 of the Constitution. I taught constitutional law this last semester, so I am now an expert. And ask me anything you want to know. You want to know about the Second National Bank of the United States, which is across the street? That's the first case I taught my class, was about that bank. Okay, I need more time, Caroline, way more time. So what is the treaty clause, but it's also called the supremacy clause? Here's Article 6 of our Constitution, folks, written at that building across the street there. This Constitution, the laws of the United States, all treaties made are the supreme law of the land. So when the federal government operates pursuant to its allegedly limited powers as defined in the Constitution, the U.S. Constitution, the federal laws, and all treaties are the supreme law of the land. Federal Indian tribes signed over 375 treaties with the United States that the Senate then ratified. These treaties are the supreme law of the land. My tribe signed 11 treaties with the United States. What do they mean today? But before you get too excited and think, wow, this is pro-native, let me tell you what Congress decided in what are called the Chinese exclusion cases, and then in the Lone Wolf case, which is about a Kiowa Indian tribe from Kansas. Congress can abrogate international treaties. Now that seems a little odd. I taught both these cases this semester too. But the Supreme Court decided in the Chinese exclusion cases that Congress could enact laws excluding Chinese people from coming into our country in violation of treaties the United States had signed with China. And 14 years later, you can see that the Supreme Court made the same decision regarding Indian treaties. Tribal nations, the treaties they signed with the United States that are supposed to last as long as the grass grows and the water flows, well, I guess it only lasts as long as Congress allows. So from the Indian law perspective, this is maddening. From the McGirt situation, this is the deciding factor of the case. The McGirt case also implicates what we call is Indian country. This is a term of art. And in 1948, Congress looked back at 100 years of Supreme Court decisions and tried to take language from these old Supreme Court cases to draft a statute to define what is Indian country. Before I get into the definition, this is where tribal governments primarily exercise their sovereignty, their jurisdiction. It's primarily where they criminally prosecute people and will hear civil lawsuits, etc., and zone and regulate and tax and do all the things that governments do. So Congress, this is 18 U.S.C. 1151. It's the Federal Criminal Code, 18 U.S.C. United States Code. Indian country means, and you can read that faster than me, all land within a reservation borders is Indian country, notwithstanding who owns the individual pieces of land. Now, the word patent here, you've maybe never seen this. When you get your title to land from the federal government, it's called a patent. So this doesn't mean you invented something. That's a whole different body of law. I don't teach that. But look at that. So notwithstanding the issuance of any land title, so even to non-Indians, if you live within the borders of an Indian reservation, you live in Indian country, and including rights-of-ways, state highways, oil pipelines, water pipelines. You know, what are rights-of-ways? Telephone lines? Do we have those anymore? I was going to say telegraph lines. That's really old. Well, subpart B we're not concerned with. But subpart C is how I and everyone else taught Indian law for 30 years about Oklahoma. What was Indian country in Oklahoma? It was just these little pieces of land called allotments. And as you can see, the Indian titles to which have not been extinguished. So what does that mean? That means that the tribal nation still owns that little piece of allotted land, or an individual Indian still owns that piece of allotted land in trust with the United States. Maybe you've heard the phrase trust lands. What does that mean? The United States is the legal owner of these pieces of land. The Indian nation, or the tribe, is the beneficial owner. And that's what we call and what we mean by trust lands. The United States is like the trustee and holds the legal title for the benefit of the wards, which the United States called us in 1831. So Indian law has always been taught for Oklahoma. The only Indian lands were allotted lands. But what McGirt says is there are reservations in Indian country today. That's the bombshell. So I'm talking about the Muskogee Creek Nation because they are the tribe that was at issue in McGirt. McGirt is a heinous criminal. He is an Indian person who committed a crime inside the old, we all thought, Muskogee Creek Reservation. But as an Indian, if he committed his crime in Indian country, the state of Oklahoma has no criminal jurisdiction over him. And so he and his attorneys argued for over a decade that the Muskogee Creek Nation's reservation from 1866 still exists. He's an Indian. He committed his crime in Indian country. Ergo, the state of Oklahoma has no criminal jurisdiction over him, and he ultimately wins in front of the Supreme Court. But what led to this? You may all know the removal, the Trail of Tears we talk about, the tribes from the American Southeast. Well, my tribe was removed from mid-Ohio in 1832, and we may have been one of the first tribes to arrive in Oklahoma. Anyway, we're focusing on the creeks. So part of the effort of the feds to force the tribes west, we always blame Andrew Jackson, folks, because that's when Congress passed the 1830 Removal Act. But President Jefferson, that belighted, oh good, I'm glad his face is covered up. After writing about Jefferson and researching him, I don't think he's the saint that I think. He wrote privately that all the tribes would have to move west someday. Why? Because Americans wanted our lands, our assets, etc. Okay, that's a different story. I'm already having time troubles. Okay, the Muskogee Creek Nation was being ordered to move west. President Andrew Jackson said, I will not protect you from the states if you stay where you are in Alabama and Mississippi. You will be subject to state law. So the leaders of the Muskogee Creek, not being lawyers, not having American education, showed how intelligent they are. They said, we will move west, but we want the fee simple title to the lands you select for us. Now, if you know anything about American property law, folks, the fee simple title is the highest and most sacred form of American land ownership. And so here the Muskogee Creek, what they know about American English law? But they go, we want the fee simple title. They also demanded, here's language from that 1832 treaty, a permanent home guaranteed to us, we will govern ourselves. Look how smart they were. We never want to be under a state or even in a federal territory again. Do you promise the United States? And of course, the United States lied and promised. The Muskogee Creek knew what it meant after what Andrew Jackson had done to them, to threaten them with being under state law, that they never wanted to be under state law again. They signed another 1856 treaty. No portion of our lands ever be inside a territory or state. We have the unrestricted right of self-government and full jurisdiction over our properties. Well, folks, during the Revolutionary War, the Union troops withdrew from what now was called the Indian Territory. Even the Indian Bureau of Affairs agents withdrew. And guess who marched in with cannon and bayonets? The gray-clad Southern soldiers. And so what did the tribes do in what's now Oklahoma, my tribe included? We signed treaties with the South in 1861. So when the Civil War ends, the United States used that as an excuse to punish the tribes in the Indian Territory. Now, if you may know, we think it's a pretty big deal that we didn't punish the South at all. I mean, there was the Reconstruction era, there were problems, of course, but we didn't take land or money from the southern states. But boy, the United States used this as an excuse to take land and rights and assets from the tribes. So at Fort Smith, Arkansas, a United States representative said, your past treaties are forfeit because you allied with the rebels, and you're going to sign new treaties. They forced the Muskogee Creek Nation and others to sell to the United States half of their lands. The Muskogee Creek Reservation before 1866 was 7.5 million acres. And after this treaty, they reduced to 3.25 million acres. But look what the Creek leaders demanded. It's forever to be a home for us, and the treaty for the first time ever used the word reservation. Now that's really not a surprise, because the word Indian reservation only became a term of art in about the 1850s. This occurred in Texas and California when lands were being set aside to move Indians out of the way of the stuff Americans wanted, I ironically say. But anyway, the use of this word reservation is crucial to the McGirt case, because what does the tribe hold? A reservation. Now, my co-author, well, let's show the map. So after signing these new treaties, folks, take a look at what is today Oklahoma. Those 5 big tribes all were forced to sign treaties selling half their land. Well, heck, there'd be no state of Oklahoma today if it was all an Indian country. And I say, good. I'm being recorded, aren't I? Governor Stitt, I didn't mean that. Governor Kevin Stitt. But you can see how much of Oklahoma was ceded, forcibly sold by these 5 tribes. So what is the remainder, though, of the Creek Reservation? That 3.25 million acre promised in the 1866 treaty forever. Over time, Oklahoma resisted it, fought it, made it resist, or made it, we all assumed the reservations in Oklahoma had disappeared. So the question facing the United States Supreme Court in the McGirt decision, I finally, with 5 minutes to go, got to the McGirt decision. Did Mr. McGirt commit his crime inside a reservation. If he did, the state of Oklahoma has no criminal jurisdiction over him. He must be let out of state Oklahoma penitentiary. So this is the simple question that was presented to the U.S. Supreme Court. The Supreme Court has decided 9 cases from 1961 till McGirt in 2020. When has a reservation been diminished or completely disestablished, it's called. Now remember, Congress can change treaties. So did Congress ever change the Muskogee Creek Reservation and either diminish the borders or completely disestablish the reservation? The Supreme Court developed a 3-part test. If I had an hour, I would talk to you about all 3 elements. Here's where the court stopped. Justice Neil Gorsuch, relatively new to the court, April 2017 he joined the court, Trump's first appointee, deemed to be very conservative, but he is pro-tribal and pro-Indian law. Since he's been on the court, he has voted 85% of the time in favor of the tribal argument, the Indian law position. Now you might think, well, how does that number compare with the great liberals like Ruth Bader Ginsburg and Stephen Breyer? Ginsburg only voted pro-tribal 49% of the time. Breyer only voted for pro-tribal 39% of the time. So Neil Gorsuch, for those of us who practice Indian law, my gosh. Anyway, number 1 step, what did Congress say? The only way to know if Congress intentionally and explicitly meant to diminish a reservation or to completely disestablish it, what did Congress say? So Oklahoma argued 8 different federal laws to the Supreme Court and earlier cases in front of the 10th Circuit Court of Appeals, United States Court of Appeals, and Gorsuch and the 4 liberals. So McGirt was as close as it gets, 5-4. Gorsuch, the 1 conservative, writes the opinion and joins with the 4 liberals to hold that Congress has never said a word about diminishing the Muskogee Creek Res or completely disestablishing it. So what does that mean, folks? It still exists today. So this is when my wife woke me up. She's a lawyer. I knew she knew who won the case and could read the newspaper, but I still went to Westlaw to download the case. And let me go 2 slides ahead. Here's the opening sentence of Gorsuch's opinion. Do you think the tribe won? I went, Molly, you are correct. On the far end of the Trail of Tears was a promise. So the book that I and my co-author wrote on this case, we call it A Promise Kept, the Muskogee Creek Nation and McGirt versus Oklahoma. But where does Gorsuch stop? Let's see, how do you go backwards? Step 1, there are 2 other steps, and the majority don't even go to that analysis because there is no statement from Congress that even hints that it meant ever in these 100 years, 160 years, to change the borders of the Muskogee Creek Reservation. So step 1 under the Solem test, no clear statement from Congress, go no further. Now, I can't help but saying this, folks. So Gorsuch is an originalist, right? He's a textualist, if you know what this means. So he really just wanted to focus on the language of Congress. But I can't say that word. I was going to say a word. The other 4 conservative justices who all claim they are originalists and textualists, they demanded he go to step 2 and 3 of Solem and forget about what Congress really said. Now, the word I was about to say was hypocrisy. So I've said it anyway, didn't I? Originalists, ignoring what Congress really said or did not say, and wanted to go to later evidentiary points to try to say that the Muskogee Creek Reservation was disestablished. Okay, I'm getting short already, aren't I? 1860, well, I've always been short. I meant short on time. The entire area is Indian country, folks. My co-author and I tried to extrapolate how much land did the Muskogee Creek Nation and did Muskogee Creek people hold in trust with the United States on July 8, 2020. We calculated it was about 135,000 acres. So it was those little pieces of allotted land I mentioned earlier. So yes, there was Indian country in Oklahoma, but it was under 18 U.S.C. 1151C because it was allotments. On the morning of July the 9th, 2020, we just found out that the Muskogee Creek Reservation is 3.25 million acres, and it's Indian country under 1151A because it's a reservation. Now, if that's not a bombshell, I don't know what was. I think I mentioned this already. Some people told me I was hyping this a little bit. No, and I'm going to get to my last 2 slides in my last 10 seconds. Gorsuch, I don't have time to say anything. There's 3 seconds. Let's get to this. You can read this fast. A few more seconds. Can I have like 5 more minutes? Folks, 46% of Oklahoma is now Indian country because the Oklahoma state courts took the analysis of McGirt, which they have to do, federal law is supreme, and they have found and re-recognized at least 8 or 9 other reservations. My own tribe's reservation was re-recognized by an Oklahoma state court about 9 months ago. Now, we only have 14,000 acres. Well, it's better than nothing. But folks, I want to tell you a moment. I live and work now in Arizona. We have always been the state with the most Indian country inside the state because of the great big Navajo Reservation, San Carlos Apache, White Mountain Apache. Arizona was 27% Indian country. And Arizona had a big problem with this in the 50s, 60s, and 70s, litigation to the Supreme Court. But look at Oklahoma. And I want you to think a moment. If you're the governor of Oklahoma, you're the legislature of Oklahoma, are you in shock? Was this a bombshell? Are there big impacts? Well, as we say in the law, duh. At least we say that in my class. So 3 weeks ago, there was a conference, and one of the panels was, what's wrong with Oklahoma? And one of the attorneys for one of the tribes said the McGirt decision opened a fire hose on the tribes. Okay, I see Caroline starting to look at me quick. So the tribe's jurisdiction increased by 25 times, folks. Every one of these tribes in Oklahoma is hiring new judges, hiring new police, hiring new prosecutors, hiring new criminal defense attorneys. They need child welfare departments that now cover 25 times the terrain and people it used to be. If you've never heard of the word a cross-deputization agreement, in just a year, the tribes in Oklahoma signed 210 cross-deputization agreements with cities and counties. If you recognize our cops arresting non-Indians, we will recognize you county and city cops arresting Indians. So they were working out these now brand new, enormously important criminal jurisdiction issues. The Cherokee Nation has begun to sign an agreement. Okay, I got to get done. The Governor Stitt is in shock. He still is. Here's what he said in 2021. I don't think there's ever been a bigger issue to hit a state. The Oklahoma Tax Commission said we will lose $300 million in taxes the first year and $200 million every year going forward because of McGirt. Because an Indian who lives and works on their own reservation does not pay state taxes and does not pay state sales tax. Look at what I have there. The credit rating agencies said we will consider lowering Oklahoma's credit rating later if the tax revenues really. Wow, what governor wouldn't be upset? How much time? The federal government finally noticed all of this is Indian country. There are hundreds of laws, folks, federal laws, that apply in Indian country. And so the federal responsibility in Oklahoma increased 25 times. And all of a sudden, all these federal laws apply. And you can imagine a red state as Oklahoma doesn't like the feds coming in. So the feds the Federal Office of Surface Mining wrote a letter in April 21 to Oklahoma saying, oh, by the way, that McGirt decision, you no longer have jurisdiction over surface mining in eastern Oklahoma. We will take over, the feds. Well, you know the state didn't like that. You see the state sued immediately, lost immediately, and is currently appealing that in the 10th Circuit Court of Appeals. But here is an impact that Indian country is not too happy with. Because of McGirt, Oklahoma brought this case. Now, everyone thinks this was a change to McGirt. That is totally wrong. It did not change McGirt at all, but it happened because of McGirt. So Oklahoma wanted to be able to prosecute non-Indians who commit a crime in Indian country where the victim is Indian. And the U.S. Supreme Court, in a change of 200 years of Supreme Court precedent, said, yes, Oklahoma can sue or criminally prosecute Mr. Castro Huerta. And they didn't say this is just Oklahoma. They said this applies to Indian country in the entire United States. So this has even made McGirt more substantial, because now it has had an impact in Indian law, general Indian law, that has impacted every tribe, every state in the country. I see someone is standing over here. So the Oklahoma Supreme Court is deciding issue after issue now and making incorrect rulings. The Indian Child Welfare Act, this is an odd interpretation, but because it's the Supreme Court of Oklahoma, only the U.S. Supreme Court can review it, and only the U.S. Supreme Court can fix it. And what did I tell you? How many cases does the Supreme Court take a year? 1% of what they're asked. So this is the last slide, Caroline, I'll be done. Folks, the city of Tulsa is the second largest city in Oklahoma. It is now totally within either the Muskogee Creek Reservation or the Cherokee Nation Reservation. They now cannot write traffic tickets to Indians. And this case from the 10th United States Court of Appeals, the 10th Circuit Court, has now been remanded to district court to continue trying to decide whether there are other federal laws that might allow. But so, I mean, the joke is, if you're a native, drive 100 miles an hour down the streets of Tulsa. But your tribal governments don't want that either, do you? The tribal governments want to prosecute these type of people. They want agreements with Tulsa. They want to work this out. The state does not appear too interested in working some of these issues out. And that's what I fear. The state prisons don't have as many people in it. They have too many guards. The police and the judges, there's too many. I gave a talk a year ago, and 2 state judges separately came up to me and they said, we're not very busy anymore. They lost 10% of their criminal caseload and probably 10% of their civil caseload, and they aren't very busy. Justice Gorsuch recognized in the McGirt decision there would be a period of adjustment, as one government would have too many prosecutors, defense attorneys, judges, blah, 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 and this needs to morph over to now the federal jurisdiction that is encompassed in the words Indian country and tribal jurisdiction. Okay, I'll be done very, 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 very quickly. The problems in the Oklahoma government are incredible, folks. The governor vetoed some pro-tribal legislation passed by the very red Oklahoma legislature. They overrode his vetoes. He sued them. He sued the Speaker of the House of Oklahoma and the President of the Senate of Oklahoma, and he lost that just this month, 3 weeks ago. The Attorney General and the governor, look, I'm looking over my shoulder. They're suing each other right now who should represent the state in a lawsuit about tribal gaming issues. The Biden and Trump administrations have had to pour in more federal dollars like you can't believe. They are appointing 5 new federal district judges in the Eastern and Northern District, which only had 4 to begin with. So they've increased, my math's not too good, that sounds like 125% increase. Wow. Economics, there's already 2 studies out showing no difference. Decades of litigation to come, I'm afraid. The governor has 2.5 more years to serve. Maybe a new governor will look to cooperative governance, which is what Justice Gorsuch hoped would happen. If it doesn't, he says Congress has tools to fix things, and that chilled me. So I'm going to end with one thing. Just think of where you live and where you work, and think if you wake up tomorrow and there's a new government there. What would you worry? Can I be taxed? Can I be criminally prosecuted by this new government? They're going to zone what I can do in my house or my business? Now, move to Eastern Oklahoma. Thank you very much. Thank you for all that.
Oh, listen, there are going to be questions, so stay for the questions. I'm sure there will be lots of questions that will enable Professor Miller to come back to some of his points. So, questions, yes, here.
You know, professors get paid by the word, as many of you know.
That was a great presentation. Thank you so much. Setting aside the Huerta, the follow-on case, what implications do you see from the core McGirt decision for jurisdictions other than Oklahoma?
This case only applies to Oklahoma at this moment. Castro Huerta, yes, expanded it, as you mentioned. This is an Oklahoma-only case, so I suppose that's why some people thought I was hyping the issue. But there are 39 federally recognized tribes in Oklahoma, and that map I showed you folks, there are plenty of tribes in the West who also have arguments that their treaties, their reservations were never diminished. But at this moment, sir, it's just an Oklahoma issue. But the states hasn't gotten over it. It's a big issue.
Back here. Rich Schifrin, Indiana, back in the back. First of all, if the treaties were supposed to be the highest law in the land, how did it got to be justified that Congress could override that? And second of all, if they could, can they do it again to override this?
Absolutely. What Justice Gorsuch hints in a chilling sentence in his opinion is if the governments, feds, states, and tribes can't work this out, he said, Congress can always alter the treaties. So your earlier question, Rich, the Supreme Court in the Chinese exclusion case in 1889 said that a later Congress can always change a law that an earlier Congress passed. The only way to bind later Congresses is by amending the Constitution. A law from 1780 can be changed today. But what makes that weird is we're talking a treaty, not an act of Congress. So I'm still offended by that, but you asked what the analysis is. That's how the Supreme Court decided that a later Congress can pass an act, a statute, that changes a treaty. So Gorsuch warned us, treaties can be, these reservations can be shrunk.
There's a question there when you
go on the balcony.
Conrad Harper, New York City. So mindful that treaties are on the same statutory footing as a federal statute, what is your calculation about the likelihood in Congress that there will be a change?
I would think not. Tribal nations have become so politically powerful, folks, that Congress has not passed a law that tribes actively opposed since 1968. I do not think that, yes, the Oklahoma senators and the congressmen and women from Oklahoma might like to see the reservation shrunk, but we're talking about 98 other senators that tribes are going to politic. Is that the right word? Lobby. I do not think what you mentioned could become a problem. That's my hope. I certainly hope my 14,000-acre reservation stays intact. That's where my grandfather's allotment is.
There are two questions back there. Yeah, here with the microphone.
I don't know which way to get it. Best, yeah.
Linda Greenhouse, Stockbridge, Massachusetts. So assuming that many people who live in what's now Indian country are not Indians, what are the implications for them? After all, they can't vote in tribal elections, and so they're living under a jurisdiction that they have no say in.
I forgot to give you the last bullet point. 1.8 million Oklahomans now live on a reservation. And 90% of them are not Indians, as you point out. So those questions I asked, you need to take my whole class, Linda. That's the only answer. The Supreme Court has decided many issues about when tribes have criminal jurisdiction over non-Indians, which is almost never, and when tribes have civil jurisdiction over non-Indians. There's a Supreme Court test, Montana versus United States from 1981, but you just need to come take my class. But think of the uncertainty, folks. This is the very reason the credit rating agencies said, we're going to see how this plays out, and we may lower the Oklahoma credit ratings and the counties and states, which could cost them tons of money in the future. If you understand what municipal bonds are and how governments build infrastructure, hospitals, roads, etc., your bond rating determines how much interest you have to pay. But anyway, I digress there. But every one of these issues is yet to be decided. So it can either be litigated for the next 50 years, folks. That's what I say in my book. Or what Justice Gorsuch and the majority hoped was it would be cooperatively worked out. Gorsuch pointed to the fact that the state of Oklahoma and the tribes for over 50 years had been working pretty well with what we call compacts, which is a negotiated contract between governments to handle criminal jurisdiction, license plates even in Oklahoma. Tribes issue license plates in Oklahoma. Gaming, tobacco, fishing and hunting. These things had been worked out fairly well, but the governor has so lost his mind. Notice his name is Governor Stitt. That rhymes with something. Anyway, we'll see how that works out.
Thank you so very much. Great. There'll be more questions at the break, I'm sure.